Welcome to the India's first podcast of ODR, Online Dispute Resolution, presented by Lawchemy. I am Rashi Yadav, your host, a legal content creator and a legal educator. Today, we are joined by Aditya Shivkumar, an advocate, entrepreneur, and a founder of RDO. So, a platform deriving in dispute resolution through technology. Before we dive into ODR, AI, and technology, I would love to begin with your journey, sir.
Wonderful. Thank you so much for having me, and it's a pleasure to be part of Lawchemy. I've heard about Lawchemy for quite some time, and you've got a wide variety of audiences from various parts of the country. So thank you so much for having me on your show. Uh, so as far as my journey is concerned in the field of ODR, I must congratulate Lawchemy for choosing a
Yeah.
title that affects the common man, which is how does one look to tackle the access to justice problem? The access to justice problem is incredibly fundamental, and it's part of it. It's perhaps one of the very few pieces of pillars in the legal field that can actually have a transformational effect through technology. Now, through online dispute resolution, you can look to make a discerning impact on the day-to-day lives of the common people that trust the judicial process. So my own journey began as my career as a litigation lawyer. I did my law in England. I qualified for the bar, where I was one of the youngest mediators in England at that point in time, way back in 2008. I got accredited by the Civil Mediation Council, and there was something that was not sitting well with me. I was trying to see how can we fuse technology and law together way back in those times, and that's when we said, let's try and bring in mediation and arbitration into the legal fold and try and see if we can fuse that with technology. Now, my experience as a litigator, as well as my interest in the field of technology, is what brought me to the crossroads of law and tech.
So, sir, you have been practicing law for 15 years, right? Take
Yep.
us back to the beginning. What drew you towards law, and was there a particular moment where you realized you wanted to do something beyond traditional courtroom litigation?
See, today, when I began my career in 2010 as a litigation lawyer, I came back to the Madras High Court, one of the charter high courts of the country, an extremely prestigious high court. Uh, I began my career as a litigation lawyer working under the former Advocate General of the state, where I saw firsthand the challenges that people face. Because today, nearly 35-40% of the litigations that are there in courts today are all governments as respondents. So you have the writ practice that is possibly one of the uh, key pivots for making a change in the system. Now, 2010, I began my career. I had a deep interest in sports law, so I decided to take up representing sporting federations. I had the opportunity to work with the former Chief Justice of the Punjab and Haryana High Court, Justice Mukul Mudgal, who is regarded as the father of sports law in the country today. Uh, I then saw firsthand of the challenges that people face as far as you take a routine writ case that comes to the High Court, any high court for that matter. It could be as simple as a writ of mandamus or a writ of certiorarified mandamus that you would look to ask the court, and the court would direct the government to execute that particular, or direct the government to consider the representation and dispose accordingly. But then that got me thinking. I was like, is that justice at the end of the day? Is that
Yeah.
is there a better way that we can make the system a bit more efficient? And one of the ways that I thought was, how do we fuse technology into this particular space? I often regard law to be the last bastion or the last frontier where technology has not penetrated. In 2012 to 2014, you had fintech coming up, you had pharma tech coming up, you had your real estate technology coming up, you had all those things embracing technology. But law and the judicial sector was possibly the last bastion where technology couldn't penetrate. And I wanted to take that up as a challenge and see how we can make an impact to the courts as well as the citizens.
Oh, that's fascinating, sir. I think many young lawyers start their journey primarily about litigation. So it's interesting to understand your perspective evolved. So let's move further. Uh, you came from a family. You came from a family with a remarkable constitutional and legal legacy, right? So growing up around that environment, did it feel like a responsibility to carry forward that legacy, or more like an inspiration that stopped your thinking?
The uh, legacy will only get you that far and no further. I always believe that. Legacy will only get you to the door. But beyond that, it is your passion, it's your commitment, it is what drives you that makes you who you are at the end of the day. So for me, I had a passion towards law as well as polity right from when I was a young kid. Mostly because I used to grow up with stories, listening to my forefathers who have left an imprint on the Indian constitutional framework as well as shaping up of the country. So when you hear these stories, there is that 1 or 2% of interest that sparks in your mind. So I was very focused from when I was in my fifth standard or sixth standard. I decided I want to be a lawyer. And legacy comes with its own share of problems. From the outside world, legacy is great, but legacy also means that there is added responsibility of how you want to make that impact on the ecosystem. But definitely,
That's really
but
that's
definitely for me, I felt that that constant nudge at home, that constant discussion of how my granduncle was working at that point in time, in how he shaped the constitution framework, all had a lasting imprint on what I wanted to do.
it shows how early influences often shape the way we think about institution and public service. So yeah, let's move. You became one of the youngest certified mediators under UK Civil Mediation Council. How did the experience shape your understanding of dispute resolution? And there was a point where you began connecting mediation with technology.
The, globally, if you look at it, technology has always sat in the intersection of law and access to justice around the world. Now, I was fortunate to do my law in England, and which I regard as the hotbed of litigation as well as for lawyers. I call that as the mother of the legal system and the mother of the legal framework. So for me, when I was there around 2008, 2009, when I became a qualified mediator with the Civil Mediation Council, they were all already talking about how do we start resolving disputes through emails? How do we start resolving, how do we have a mediation through asynchronous communication? How do we have a mediation resolved in the most efficient manner. Now, all of this leads up to one single word, which is called technology, and technology transformation of the disputes that can unclog an already clogged judicial system. So
That's a powerful insight.
for us, for me, it was an eye opener. And then that's when we decided as a collective, me, my co-founder, all of us, we decided as a collective that we should try and give back to the society in your own way. When you make an impact on the society, it has to be felt by them. It has to be appreciated by them.
Yeah. And I think it creates a perfect bridge to our next topic. And I really appreciate your answer and I really love it. So let's talk about resolve disputes online. What problem were you trying to solve when you started the platform?
See, my journey into online dispute resolution began in 2011. We were way ahead of our time. We, my co-founder and I, we decided to, as part of our commitment to be in the cross section of technology and justice, we decided that we will identify one single problem that everybody was facing. That was the time it takes for you to move from the court of first instance all the way up to a judgment in the highest court of the land. Now, in England, it used to take at least 45 to 50 months, even for a simple case of a landlord tenant eviction. So we said, let's put ourselves in the deep end of the sea and let's try and launch a platform that will connect directly to the consumers and the citizens. So we came up with our startup called Mediator Online in 2011. It was perhaps the first B2C platform in that part of the world, and we were way ahead of its time. But that taught us enormous insights into how people think, how systems think. And for us, that particular venture was a spectacular failure for us. And I keep saying this because if that failure didn't occur to us at that point in time, we wouldn't have founded RDO as a initiative that can work with courts, that can work with businesses, and that can help their judicial return on investment index tick up. So we've had like almost around, so the time period between 2011 to 2014 was where we decided to do a B2C venture. We had some of the best feedback from clients who said that your product is not worth its salt, your technology isn't great. And then 2014, we said, let's go to the drawing board and say, what are we not doing right? Or what is it that we have missed? And we felt that the model itself was very warped. So we decided to transform courts across the world. We decided to go sit behind the very systems that are there today to give justice to people. So we said, we will sit with you guys. We will sit with you. We will work with you. We will ensure that your existing processes is far more efficient with a piece of technology.
So, as per my understanding, that's something many people don't realize, right? Innovation often begins with identifying a problem that everyone has expected as normal. So, US courts adopted the ODR model much earlier than courts in India. What do you think that happened, and what lessons can India learn from that experience?
See, uh, more than the US courts, I would say that our early successes came from Southeast Asia, where in 2018 or 2019, we had the Singapore Mediation Council embrace ODR. We had the Thailand Arbitration Council embrace ODR. So we had a lot of governments, even closer home, that tried to bring in technology as a way to resolve disputes. Now, the US courts, on the other hand, went down a very different path. They had what I would call as a judicial transformation 2.0, where each and every court, every state court in the US had what is now known as a chief innovation officer. Now, this chief innovations officer's only role is to try and see how can they digitize and bring in digital transformation to each of their courts on a year-on-year basis. Now, for us, that had a significant buy-in because the chief innovation officer's outlook to digital transformation would be is how can he make his or her court a lot better? How can he solve the problem of pendency? How can he solve the problem of uh, easy access to possibly a mundane dispute that may arise? And I think what the Indian courts have to learn is to try and see how to let go of certain disputes that don't need the time of the court. Outsource it to online dispute resolution courts. Set up courts that are empowered to offer online dispute resolution within the judicial framework, and try and see how dispute resolution can be a mainstay for the judicial system in the country. And I would say that having a chief innovation officer in every high court is very, very essential today for the judicial system to embrace technology.
Yeah, I really appreciate your perspective, and I absolutely agree with that. So, moving further, many people think ODR simply means moving court hearing online. What's the biggest misconception people have about ODR today?
See, what people say about ODR is they feel that you see it's to do with the mindset of the country. If you look at the United States of America, you look at Europe, you look at some of the most advanced technologically driven systems, people want a solution. The mindset of the people is that for them, they don't want a problem in their day to day living. So they embrace ODR, and the judicial systems in those countries have made it hard for people to even file a case in the court of first instance. Today, if you look at the Indian ecosystem, it is very easy to file a case in the High Court or the District Munsif or the City Civil Court. And it's extremely easy for you to take a problem to the court. There is no deterrent. Unless the judicial system comes up with a deterrent to say that unless your dispute is less than 25 lakhs or 30 lakhs, you should not even come to the district court with your cases. We have a setup. We will create an online dispute resolution court with qualified judicial officers whose only job is to resolve these kind of disputes that can unclog the already clogged judicial system. So I feel that people today,
Okay,
when they look
that's
at
probably
ODR, Rashi, what people feel is that in mature markets, it is a great pathway to resolve their problem. As far as India is concerned, in India, there is still a lot of, uh, they still want to do it the old way, where they want to go to court. They put their egos above their problems, which is a very big issue today. And the moment you put the problem before your egos, you will find that online dispute resolution will be the best pathway for you to resolve your issue.
absolutely. And I think that's probably the one of the simplest and clearest explanation I have heard. So, okay, let's play a choose one round. Okay. So let's go. Courtroom or a boardroom? Choose one, please.
I would say reform.
Oh, that's great. I really love this. Okay, let's moving further. Law books or real world experience?
Real world experience.
Litigation or a mediation?
So you put me in a spot there. Uh, I love both the worlds. So I would
Mhm.
say, I mean, I would still say digital transformation.
Tradition or innovation?
I would say innovative traditions.
Okay. Very interesting answers. So let's now look at the future of ODR and justice in India. India has one of the largest pending cases backlogs in the world. Do you think ODR can realistically help address these challenges?
Short answer is yes. The longer answer is the judicial system needs to develop a judicial spine to address and provide technological infrastructure for citizens as well as for the lawyers to work within a particular framework. Now, I use the word judicial spine very judiciously because the moment you're not ceding control of what is the existing system, you are only making it more efficient. You will still have judges, you will still have lawyers, you will still have your existing e-filing, and you will still have all of that. But you will just not be in court arguing these matters. You will use a online facility where you can have dedicated online dispute resolution courts. You can give them a pecuniary jurisdiction, and you can train your lawyers and judicial officers in that particular ecosystem and offer it to the citizens. That is purely digital transformation. So what I see here is there is a uh, lack of a better phrase. There needs to be that transformative curve. India needs to go up that transformative curve to understand that ODR is here to stay. And ODR is not a threat to the judicial edifice. It is a complementary partner to ensuring that cases can be resolved within the ecosystem itself.
Uh, I think that's an important distinction. So let's move further. When we talk about ODR, as it is primarily an efficiency tool, an access to justice tool, or both? What's your opinion?
See, I think you have to look at it in two ways. One is at a macro level, what is it trying to solve? A court backed, a system backed online dispute resolution protocol will improve the country's access to justice index across the world. Simultaneously, it would also help in the judicial innovation of the particular country, of our country. And I believe that it is you can't say that it's either an access to justice tool or a judicial efficiency tool. It is a tool that will inspire confidence of the people in the courts once again.
Yeah, that's a perspective many people may not have considered, right? So, okay, let's move. You have spent your career resolving disputes after they happen. Can technology help prevent disputes before they arise? Is prevention ultimately more powerful than resolution?
Absolutely. See, we have a lot of systems around the world, especially with AI, that has come into the ecosystem right now, and that's come into the legal day to day. I mean, every lawyer today uses AI today to understand how can they be more efficient. So I feel that post facto is always easy. to have a 2020 vision and say you should have done that earlier. But with AI, I see enormous possibilities of prevention emerging around the world. And the beauty about prevention is that it immediately showcases to either the court or the enterprise the impact it has on the top line and the bottom line if it is an enterprise, and if it is a citizen, on what the impact it would have on their longevity of the court cases, and what it would impact on their fiscal exposure. So prevention is definitely ideal, and I see that change happening over the next 6 to 8 months around the world, where flagging up of preventive dispute protocols will emerge very, very soon.
Oh, that's fascinating way to think about the future. So, where do you draw the line between technology assisting direction making and technology actually making decisions?
See, I don't believe technology can make decisions. I believe that technology is a great executive assistant in your day to day lives. And even if it were to come into the uh, judicial framework, it would only be a tool or a platform that can make it a bit more efficient and effective. You cannot have, you cannot outsource critical thinking. You cannot outsource decision making to agentic AI or technology where they lack two critical components that is required. One is experience, and second is empathy. Justice is all about empathy. Law is all about critical thinking. It can help you move faster, but I believe that technology will slip into the hallucination rail if we outsource critical thinking to it. Because
That's
the most powerful piece of technology ever invented is the human brain.
absolutely, that's a very important distinction. So, as AI becomes increasingly involved in decision making, what concerns you the most?
That humans have begun trusting AI more than they trust their human brain. You cannot outsource your uh, thinking to AI. AI, what is AI at the end of the day? AI is models created by humans who have coded on the other side of the platform. Now, we do not know whether the humans that have coded have got any bias when they were coding a particular model. What is the integrity of the models that have developed? So I feel that uh, AI today is at best complementary, and you cannot look at AI being the mainstay of your decision making, be it in court or be it in boardroom.
That's a question many legal professionals are actively debating today. So, if an AI driven system makes an incorrect decision, what should ultimately be accountable? The developer, the institution, the regulator, or someone else?
So I don't know if these questions were pre-synced, because you're asking me some very interesting questions on how AI and decision making will take place. Now, just around a minute ago, you spoke to me about the importance of pre-dispute and how disputes can be prevented. Now, I find both these questions to be interlinked in my understanding, because to know whether an AI makes a mistake or not, or to know whether an AI has made a mistake when it is making a mistake, is by far the next big thing I foresee in the AI realm. So today we use a lot of AI tools in the in especially within the legal fraternity. We rely a lot on AI to generate drafts. We rely a rely on AI to generate writ petitions. We rely on AI to do our fundamental research. But what we don't know is whether the AI itself is accurate or not. Who checks AI today? So if AI makes a mistake, and this has happened in a couple of courts around the world, is the AI has relied on two or three cases because the person who's using the AI wants a particular solution to their query. So they have relied on case A versus B, hallucinated a particular problem, hallucinated a citation. The lawyer has submitted that particular case to the court. And when the court decided to see where is this citation, the citation is missing. Now, when the citation is missing, what do you do? Therefore, unless there is and unless there are strong protocols in place to verify the AI before it comes up with a decision, we will be it will be the story of a tiger by the tail.
Yes. I think every law student listening right now should pay attention to that answer. And I would really appreciate it. You just explained so well. I really admire that. So, based on further discussion, let's play a quick round, okay?
That
So let's choose one. Sorry.
Sure, go ahead.
Okay, okay. So let's play a quick choose round. So AI judge or a human judge? What will
Human
you
judge.
choose?
Human judge.
Speed or accuracy?
Accuracy.
That's great. Innovation or regulation?
Innovative regulation.
Wow, I'm really impressed. So technology or trust?
Trustable technology.
That's great. Let's move from codes and technology to another area where governance is becoming increasingly important. Let's move further. So, alongside ODR, what you have been deeply involved in sports governance. How did that journey begin?
See, I was always passionate about sports law. And when I came back from England in 2010, I wanted to carve a niche for myself. And I decided to look at a particular discipline within the litigation framework and try and see how I can make a difference there. And that particular discipline turned out to be sports law. Now, sports law, not many know. I mean, now it's become extremely popular, but in those days, it was it was what intellectual property was in the early 2000s. It was an emerging area. It had very few practitioners in that part of the decade. And I always connected myself to sport ever since I was a kid. I've played almost every other sport. I'm a classic case of jack of all trades, master of none. Because I've played cricket, I've played football, volleyball, I've played kabaddi, I've played badminton, I've played every sport, but I've never excelled in anything. But that taught me something. It said that you don't have to necessarily be a sportsman to make an impact. You can also try and see how you can reform institutions, how you can make sport a better place, a better platform for sports people across the country. Like how technology and the legal sector and the judicial sector how judicial sector was the last frontier for technology. Had COVID not taken place, as far as sport is concerned, only now we are seeing a lot more awareness of sports and sport driven reforms that have come into the country. So for me, sport was very personal, and I was just fusing my litigation experience, my passion for litigation and sports, and trying and see how to uh, be involved in reforms at that point in time.
That's a powerful insight. So, why is governance so important to the future of sports and esports?
See, today, the last reform that took place in the country as far as sports law is concerned was in 2011 when you had the National Sports Code. For the better part of the last decade and a half, India has never had any great reform in sports in whatever format. It was only under the leadership of the Prime Minister that the sports vertical, the Ministry of Youth Affairs and Sport, after extensive consultation, came up with the National Sports Governance Act of 2025 and the National Sports Governance Rules of 2026. This, by far, is one of the most tectonic reforms in sport governance in the country. What has happened in the past is sporting federations have always been the breeding ground for Nepo kids. Now, that has transformed. Now, today, unless you have a good intent to leave an impact in sport, reforms are not going to aid you. So, sports governance is one of the key critical verticals that the Honorable Prime Minister's government has taken it very seriously, and they have given it to the sports administrators of the country. Uh, having said that, esports is something that I'm extremely passionate about because that is the future. See, today you take a example. When I was growing up, or when I think a couple of people in your audience were growing up, you would go to the field, you would play your game, you would get hurt. It would teach you about failure. It would teach you about success. If you were a cricket player, when you scored a 50, you would come back home and you would be like, it made my day. You were all over the moon. But you look at what is happening to this generation. This generation is extremely happy if they win a game of Street Fighter, if they win a game in PUBG, if they win a game in Mortal Kombat or Call of Duty or Valorant or any of these platforms. So we said, how can we look to create a career pathway for the next generation players? I mean, whichever decade you take, if you're a cricket player, you're a cricket player. But if you're an esport player, you're an esport player because that's what you like doing. And that got us thinking. And in fact, I'm one of the office bearers of the Tamil Nadu Esport Association. And we feel that it's very important for the next generation to have a safe landing in terms of a career pathway for them, and that's why we felt that esport will be a very, very important piece in the puzzle to tackle and to handle the next generation and to give them a guidance on how esport too can make you a successful sports person.
Yeah. Absolutely, I agree with that. And I think we should be more concerned about the young generation. That's incredibly a good answer. So, what role can dispute resolution play in creating trust and fairness within sports ecosystems?
See, in fact, it's a very interesting question because we have actually created the first ODR platform for sports resolutions in the country. It is called as the Center for Entertainment and Sport Resolutions, that's headquartered out of Delhi, where we feel that clogging up, see, any sporting dispute today can be resolved if you sit across the table. You don't have to necessarily go to the court. And you don't have to necessarily go to the court to understand what has to happen. You can the dispute resolution ecosystem that we have built through CESR, which is the Center for Institute of Sports Resolution, Center for Entertainment and Sports Resolution, creates a framework for sporting disputes to come in, ensure they are resolved, and move forward. It makes the whole experience a lot more pleasant, and it makes the experience a lot more forthcoming. So for any future sports administrator, you would have a sense of happiness taking up roles, because you feel that if there's any dispute, there is an ODR platform that is available to sort out. Because one of the key things that ODR does in any ecosystem is that it absorbs the negativity and the emotional charge that people have when they go to court, as opposed to if you're on an online platform, the online platform absorbs that for the individual.
Yeah, that's an important point. So, moving further, a common theme across your work seems to be institution building. What does institution building mean to you?
See, institution building to me means working with the existing system, ensuring you're plumbing the existing system to ensure that you make it a lot more efficient. The future of, see, we live in an ecosystem where everybody today is very trigger sensitive. Tolerance is not there. But institutions have outlasted tolerance from time immemorial. So the stronger the institution is, the more broad-minded the institutions are, the greater impact it is for the culture and the edifice of a particular country. Now, I strongly believe that institutions here are there to create a lasting impact on people. It can be sports, it can be technology, it can be the legal institutions, whatever institution it is, unless there are strong foundation for institutional building, there will come a time where we would thank our forefathers for building strong institutions that is able to act as anchors and as guardrails for the next generation. Because institutions always outlive individuals. That's a fundamental understanding that the next generation, through your podcast, I would like to share to all your audience and other young generational aspirants, the Gen Z and the Gen Alpha, is that have faith in institutions, have faith in institutional building, because they are the people who will outlive your legacy and outlive what you foresee it to be.
I agree, and that's a thought provoking answer. I hope it helps to all the legal law students and everyone out there. So, what do young lawyers often underestimate about legal innovation?
See, you'll be surprised. A lot of people today who are trained lawyers today want to jump into the field of education innovation. Now, in fact, you won't believe that in one of my esport initiatives, we have two litigation lawyers who have jumped from litigation to be esport content creators. Today, innovation seems to be the hallmark for any future lawyer in the country. The future lawyer should know how to understand technology. The future lawyer should know how to understand the power of AI. The future lawyer must know how to understand the power of coding.
Absolutely.
These three are extremely fundamental for the lawyers of the next decade, which is what all the national law schools in the country must start teaching on. How does a lawyer interpret a prompt that an AI puts in? the lawyer must be trained to understand whether that is a prompt that will make his case win or will make the case lose. What is the balance of probability? So this ability of bringing innovative thinking through innovation and through technology is what the future lawyers must look at. And knowing the law today is very fundamental. And I think knowing the law is possibly only 10% of your career as a lawyer. As if you take the legal, if you take a lawyer's knowledge to be 100%, knowing the law is 10%. The lawyer of the next decade will be defined by someone who can understand code, can understand AI, can understand technology, can be at the intersection of technology and innovation, coding and law, and they must repurpose themselves. And unless they repurpose themselves, they will be left out in the race.
I think that's something every aspire lawyer should reflect on. So, if a law student or a young professional wants to build in a legal technology today, where should they start?
Identify the problem. You don't have to be, you don't have to disrupt. One thing that I've noticed in the next generation, Gen Z, Gen Alpha, Gen Beta, all these other generations that are emerging, is that they want to come up with a disruptive solution. Now, today, the foundations of India are so strong that you don't have to disrupt anything. There are problems that are there which require timely solutions. So I would advise the future lawyers who want to look at legal technology to understand what is the problem that a citizen faces and see if technology can be the answer. See if technology can be the answer for courts. So today we speak about e-filing. Today uh, uh, we speak about how evidences can be uploaded online. But one of the key problems that I've noticed is what is the integrity of the evidences that is stored? What is the integrity of case uploads that you do, file uploads that you do onto a central server? Is it tamper proof? Is it tamper? Is it? Uh, I mean, these are all certain things. These are all various problems that people can identify within an ecosystem and try and solve that problem. You don't have to do things differently because today judicial system and judiciary is a fundamental pillar of the country. So for you to make an impact in legal technology would mean how do you make that day a lot more productive for the citizen or for the law firm or for the business.
That's extremely practical advice. So, looking ahead over the next decade, what challenge do you believe will define the future of justice?
The future of justice, as I see, is split into two parts. Of course, for your critical cases that require judicial intervention, you need to go to courts. But justice can also be looked from the prism of technology, from the realm of technology. You see Middle East, you see the arbitration centers that are set up in Kazakhstan, Uzbekistan, and a few other places. You have technology judges, judges who have spent their years mastering technology. So the future of justice can mean two things. One is at a certain pecuniary jurisdiction, I mean, less than, say, 40 lakhs or 50 lakhs, you will have what is called as instant justice that every citizen can access like a UPI transaction. And then you have cases that require your presence to be in court, that require laws to be debated, argued about. For that, you go to the courts. No one's stopping you. But if you can address the pendency of it through instant justice, like how we call instant coffee and instant delivery, the last mile delivery platforms, can justice also be brought into the confines of a common citizen's smartphone? That is what I would call to be the true judicial transformation. Because a guy who's in the village living in Warangal or living in Gulbarga in Karnataka, he would not want to pass on the case as a legacy to the next generation. So can you look at how instant softwares through judicial intervention can be a catalyst for justice resolution?
Yes.
So, so,
Uh, yes, sir.
so that is very important. That I see that to be very, very powerful. So instant justice for pecuniary jurisdiction below X number, and then you go to the courts, you argue, which is your fundamental rights and your key cases that require judicial intervention through in-person hearing.
So that is the very important point you discuss. And that's a powerful question for all of us to think about. So let's play a rapid fire round. Uh, just explain me ODR in a one word.
ODR is one word.
Yes.
ODR is one word. ODR, one word.
Okay, I got it. That's absolutely incredible. So justice in one word.
Justice itself is one word, Rashi. How do you expect me to put justice in a word? Okay, let me put it this way. Justice in one word could be soul satisfaction. Today, if you
Yeah.
go, today, if you look at the number of litigants that come to the courts, you will find them to be extremely fatigued mentally, physically, financially, and if you can provide a platform, and if the judiciary can provide a platform that can address these concerns, that is soul satisfying.
So can you please tell me one book every lawyer should read?
I would suggest, I wouldn't say one book, but I would say a series of books that our practitioners themselves have written. Neither Roses Nor Thorns by H.R. Khanna, which is a very, very powerful book. You've also got the books written by one of the best known brains in the judicial ecosystem, Rani Palkiwala. You've got those books there. But uh, I would say for the lawyer of tomorrow, I would ask them to read the book on Sun Tzu and the Art of War. Sun Tzu and the Art of War will shape your critical thinking when you're facing your day-to-day battles in court. Or even the
That's great.
or even the Arthashastra by Chanakya.
I hope it will help to all the legal creators out there. So, one skill every lawyer should develop, according to you.
Patience and tolerance.
Okay, that's great. That's a wonderful note to end on. Mr. Aditya Shivkumar, thank you for sharing your insights, experiences, and vision with us today. This conversation gave us a fascinating look into ODR, technology, governance, accountability, and the future of justice. I'm sure our audience has learned a great deal from your journey and your perspective. Thank you once again, sir, for joining us. This is Rashi Yadav
Thank you
signing
so
off from Lawchemy.
Thank you so much, Rashi, and thank you
Thank
so
you, sir.
much, Lawchemy, for having me, and wishing all your audiences the very best.
Thank you, sir. Signing off.
Thank you.
So